morning, student. In last lecture, we had seen the definition of a contract and the object of which is to create the legal obligation. So we had seen the definition and the component of a definition, that is the agreement, legal obligation. What is the agreement? What is a legal obligation? We had seen in detail. So as discussed earlier, agreement is, we can say, it is about the offer plus acceptance and characteristic of a contract, that is a plurality of a person. And then we can have the same mind at the same time, that is the consensus Adam is there. So both the parties to an agreement must agree about the subject matter of the agreement in the same sense and in the same time. And legal obligation also we had seen. So today we will see, we had seen the definition of a contract in previous lecture. Today we will see the essential element of valid contracts. So there are these some essential element of a valid contract under the Indian Contract Act 1872. That is offer and acceptance, intention to create legal relation, and lawful consideration, capacity of a parties, free consent, lawful object, writing and registration, certainty, possibility of performance, and not expressly declared void. These are the, um, we can say, the essential element of a valid contract. So we will discuss one by one, that is offer and acceptance. So there must be lawful offer and lawful acceptance of an offer resulting in an agreement. Here the lawful acceptance means to satisfy the requirement of a contract act. That is when the promise, one person promise or set of promise forming the consideration for each other two parties, that whatever that promise, that should be the lawful, that's acceptance should be the lawful, and their mind should be the same at the same time. Then we have, we can say, intention to create legal relationship. So there must be an intention to create a legal relationship among the parties. That agreement should be attached by the legal consequences. When the two parties enter into contract, they attracted towards each other under the legal consequences is very important. Means that is what is the legal consequences, that is the legal obligation which is binding on both the parties entering into contract. Then of course the agreement of a social and domestic nature doesn't come do not come under the legal relationship. And why it is not come under the legal relationship? Because there is no intention to create a legal relationship. For example, the agreement of a social nature, we can say, there here we can have an example, that is an agreement to dine at a friend's house is not an agreement. It intended to create a legal relationship. One friend wanted to dine with another friend, it is not an agreement, because there is no intention to create a legal relationship. There is no intention to create a legal obligation, and therefore it is not a contract. So intention to create a legal relationship is very important. There is one another example, we can say, agreement between husband and wife, that is a, we can say it is a domestic nature also, because agreement between husband and wife also lack the intention to create a legal relationship. If for example M promises his wife N, M is a person, N is the wife of that person, M promised to N to get her sari if she would sing the song. But N sang the song, but M did not bring the sari for her. So N could not bring any action in any court to enforce the agreement. Why? Because there is no intention to create a legal relationship. Okay. So the social nature, religious nature contract are not their intention is not create a legal relationship. So in essential requirement of a valid contract, there is an intention to create legal relationship is very important. Then we have a lawful consideration, that the third essential element of the valid contract is the presence of a consideration. Consideration has been defined generally for the price by one party for the promise of the other. Means an agreement is legally enforceable when each party to it give something and get something. Give something and get something is a, we can say, the meaning of a consideration. When two party entering into contract, so the contract between A and B, they gave something. One party A will give something, B will get something. So that consideration should be lawful. So the agreement is legally enforceable only when each of the parties to it gives the something and get the something. Without consideration, no contract is valid. The consideration should be there. And why this consideration is there? The something given or obtained is the price for the promise, and it's called consideration. Is a price for something or price for the promise is called consideration. Of course, there is a definition of a consideration. The consideration may be an act or for promise to do or not to do something, that may be the consideration. Okay, and consideration may be past, may be present, or may be future. Why it may be past, may be present and future? When entering into contract, when the performance always follows latter, it is not possible that making a contract and performance of that contract at the same time. When A person promise B person something, the performance is not possible at the same time, but the performance follows. So follows later. Okay, if there is a contract between A and B for the selling of wheat bags of 100 wheat bags, 100 wheat bags of 25 kg. A will take time to perform that promise to deliver that wheat to B. Okay, at the same time, it may be not possible sometime. So it may be in a future, it may be present, at the same time is also possible, and it may be in the past. Okay, so consideration is giving and taking something. I hope you understand. Anyway, so next point is we have the after lawful consideration, we have the capacity of parties. Of course, for entering into contract, for the valid contract, that is most important essential requirement of a valid contract is the capacity of a parties. So in order to competent to contract, the parties must be the age of majority. Okay, so age of majority is more than 18 years age, we can say. The person is a sound mind. What is a sound mind? The person who is insane, person who is, we can say, lunatic, or person who is mentally retarded, he is not able to enter into contract. So the person of unsound mind is a capacity to participate to the contract, and he must not disqualified from contracting by any law to which they are subject to section 11. Must not disqualified by any law means he is not punished, or he is not disqualified due to his some criminal act from contracting by any law. Okay, so that is a capacity of parties. Then another is free consent. Actually, the free consent of all the parties to an agreement is another essential element. Okay, but what is a consent? Consent means the parties must have agreed upon the same thing in the same sense, and there is absence of free consent. We can say there is absence of free consent if there is coercion. Coercion means any kind of force, or undue influence means under the influence of somebody of natural love or affection, or a fraud, or you are misrepresenting something, or under the mistake. So these, if these factors are available in the consent contract, that consent is should not consider as a free consent. It is a influence by coercion, undue influence, fraud and misrepresentation and mistake. So this is not purely free consent to the contract. So free consent is also important essential element of a contract. Then lawful object. Of course, the for the formation of the contract, the object should be lawful. Object should be lawful. Because the object for which the agreement has been entered in must not be fraudulent. Why? Because if the object is unlawful, it is unlawful for one or more reason. Okay, like it is fraudulent, or we can say it is immoral, it is opposed to public policy, like we can say the wagering agreement sale. So that wagering agreement is also unlawful things. So the object jo ahe, object for the contract should be lawful object. The object is should be lawful object. It should not be the opposed to public policy. It should not be immoral. It should not be fraudulent. Okay, it should not imply the injury to any other person. If A make a contract with B for beating a person, beating his competitor C, so the object is to beat the C person. That is a criminal act itself. So the object should be lawful. That is a wagering agreement or agreement related to the money laundering or like that. So these objects are unlawful. So that contract will not contract is not valid in that sense. So for a valid contract, the object should be lawful. Then we have another thing is a writing and registration. Actually, according to Indian Contract Act, a contract may be oral or may be writing. It may be oral or it may be writing, but in certain cases, it lays down that the agreement to be valid must be in writing and registered. It must be in writing and registered. The example is given that agreement to gift of natural love and affection. Some people to their because of their natural love and affection to their some relatives, they gave some gift that should be writing and registered. Agreement to pay time barred debentures. For debentures have the time limit. So for paying the debentures, they have the we can say the writing and registered agreement. Then certain other acts also are arbitration, conciliation, transfer of property act. So these related to this act. So that must be we can say registered and in written actually. Okay. And then now we have the most important element is the certainty. Certainty Certainty means agreement, the meaning of which is not certain, or void agreement. In order to give rise to valid contract, the terms of agreement must not be vague or must not be uncertain or must not create any kind of confusion. It must be it must be unambiguous. It must be clear. Okay, for a valid contract. So the meaning of which is not certain or void. So certainty is the main essential valid requirement of a valid contract. Okay. Then, for example, here we have given example that A agrees to sell B 100 tons of oil. There is nothing whatever to show what kind of oil is there. There is a contract between A and B for a sale of 100 tons of oil, but there is nothing to show what kind of oil is that. That is not clear. That is not certain. So there is a confusion. There is a we can say vagueness. There is a uncertainty. So that agreement was intended for a uncertainty. So certainty is most important element of is valid contract. Okay. Then we have the possibility of performance. Of course, the contract must be capable of a performance. If A contracts B, that B can plug the stars in the sky for A's girlfriend, that is performance is not capable. Okay, so an agreement to doing the impossible act itself is not valid contract. So agreement to do an act impossible in itself is void. For example, we can say the agreement between A and B to find a treasure, find the treasure by magic, it is impossible thing itself. So of course it is physically and legally impossible to find any kind of a treasure by magic. So that act is impossible in itself. So agreement to do an impossible act is also void. So if the act is impossible, physically, legally, the agreement cannot be enforced at the law. Then not expressly declared void. There are the certain kind of agreement which are declared void under the Indian Contract Act from section 22 and 30. For example, an agreement in respect of marriage, an agreement in respect of trade, an agreement by way of wager, and such kinds of agreement, such kind of agreement declared void, because A and B, if there is a in respect of marriage, if A and B there is agreement for that A made an agreement with B, please don't marry with the C, don't marry with the C, or in respect of such kind of marriage, that that agreement is declared void in respect of marriage. In respect of trade, A and B had an agreement for not carrying the trade with C. So this agreement is also in respect of trade. There is a so an agreement by way of wager also is expressly declared void. So before dealing with the essential valid contract in detail, it will be of course we will see in the inlet sector the various type of contract, that is a void contract, voidable contract, and void agreement in the course of our discussion. So this is about the essential element of valid contract. Thank you. Thank you very much.